Thank you all so much for coming. It's great to see everyone here. Tonight will be the second event in the speaker series for the fall for the Center for Human Rights and Humanitarian Studies. And we will be discussing complementary approaches to advancing human rights, featuring Ambassador Keith Harper and our own Dr. Adam Levine. So first, I'm going to give a quick introduction to both our participants, and then there'll be a Q&A for about 45 minutes, and then a few questions, hopefully from you all. So Dr. Adam Levine is Professor of Emergency Medicine and Health Services Policy and Practice at Brown University. Dr. Levine currently serves as the Director for the Center for Human Rights and Humanitarian Studies at the Watson Institute for International and Public Affairs. The mission of the center is to promote a just, peaceful, and secure world by furthering a deeper understanding of human rights and humanitarian challenges around the globe and encouraging collaboration between local communities, academics, and practitioners to develop innovative solutions to these challenges. He also serves as the Director of the Division of Global Emergency Medicine at the Warren Alpert Medical School at Brown University. Dr. Levine received his medical doctorate from the University of California, San Francisco, and his Master's of Public Health from the University of California, Berkeley, before completing a specialty training at the Emergency Medicine at the Harvard-affiliated Emergency Medicine Residency in Boston. Previously, has led research and training initiatives in East and West Africa and South and Southeast Asia. Ambassador Keith Harper, a citizen of the Cherokee Nation, is the first Native American to be named a U.S. ambassador, serving as U.S. permanent representative to the UN Human Rights Council from 2014 to 2017. Now partner at General Bullock, Ambassador Harper chairs the firm's Native American law practice. Previously, he represented the plaintiff class of 500,000 individual Indians and served as class counsel in the landmark Indian Trust Fund's lawsuit, Cobol v. Salazar. Ultimately, the case settled for $3.4 billion with a B, representing the largest settlement of a lawsuit against the United States in history. From 2010 to 2014, Ambassador Harper served as commissioner on President Obama's Commission on White House Fellowships. He has also served as chair for Native American policy in the 2008 Obama for America presidential campaign, and then as a member of the Obama-Biden presidential transition team in the energy environmental cluster. Ambassador Harper was previously senior staff attorney and head of the Washington, D.C. office of the Native American Rights Fund from 1995 to 2006. During his tenure there, he also taught federal Indian law as an adjunct professor at Catholic University, Columbus School of Law, and at American University, Washington School of Law, both in Washington, D.C. Ambassador Harper served as Supreme Court Justice on the Supreme Court of the Porch Band of Creek Indians from 2007 to 2008. And as appellate justice on the Mashantucket Pequot Tribal Court from 2001 to 2007. Ambassador Harper is a graduate of New York University School of Law, where he served as an articles and notes editor on the Journal of International Law and Politics, and was a Root Tilden Snow Scholar and a fellow at the Center for International Studies. After graduation, he served as law clerk to the Honorable Lawrence W. Pierce on the U.S. Court of Appeals for the Second Circuit. Ambassador Harper is the recipient of numerous awards and recognitions. The ABA named him a hero for human rights in 2014, and he was elected to the American Law Institute in 2012. Ambassador Harper is a member of several boards, including American Constitution Society and Defenders of Wildlife. And for the last 2 years, he served as an appointment as special advisor to the ABA Rule of Law Initiative. Gentlemen, take it away.
Thank you so much, John. And thank you all for joining us tonight for this really wonderful conversation. And Ambassador Harper, I'm thrilled to have you with us here this evening and to get this chance to ask some questions for you about human rights from your wealth of experience in a variety of different realms. So I'll just start it off with a really basic question. What are human rights and who gets to define them? And has that definition evolved over time?
Yeah, you know, we sort of think of human rights as something individuals possess. In a certain way they do. But traditionally conceived, human rights are what obligations states owe to individuals. And we also sort of think of human rights as kind of having been here for a long time. But this idea of universal human rights, that anywhere in the world, everybody has these fundamental rights, is really of recent vintage. It's a construct, at least as far as agreed by states after the Second World War, with the Universal Declaration of Human Rights. So, to be sure, individual states provided rights to their citizens, but there was never a concept, at least agreed to internationally, of human rights. So again, if you look at the Universal Declaration, it's principally a document that reflects what we call negative rights, or those things that states are prohibited from doing. So you cannot violate freedom of expression, you cannot violate freedom of association. There are some positive type rights in there, but it's really a document of civil and political rights more than anything. And that's natural because it was drafted principally by US diplomats, or driven certainly by US diplomats. Is it evolving? It's absolutely evolving. And it has evolved since inception. For one thing, through later conventions, whether it's the International Covenant of Civil Political Rights or Convention Against Torture, they've taken the rights as stated in the Universal Declaration and sort of drilled deeper, given them more definition. And so instead of just having freedom of expression, you have an entire article that goes into depth about what that means in specificity. In addition, we have international institutions that refine what these rights mean. And of course, they're constantly changing because rights are really emerge from conversations where you are trying to resolve a problem, right? Otherwise, they're not meaningful in the real world. And so, you have freedom of expression because states were denying people the right to talk and say what they feel. And so now with technology, there's evolving rights. There's additional conversation about whether we should have more positive rights, the right to health, the right to water, the right to education. And there's a constant struggle about talking about these rights and whether or not they should be adopted and considered universal.
And you touched on this a little bit, but it's a very common question that comes up when we talk about human rights. So I want to ask it more explicitly of you.
Yeah.
How universal are human rights? Are they really things that belong to all world philosophies, or are they simply a Western construct that was forced on the remainder of the world? When you talk about human rights treaties, is it just European states that are members of them, or more broadly than that?
Yeah, I mean, the fact is, this is a constant debate, and different folks have different opinions of what they are. The entire idea of human rights, period, because the whole idea of, again, of universal rights is that they apply to everybody, and that's why they're universal in nature. So the entire idea of these universal rights is that they apply everywhere, and they apply to all states, and they're given to all people. Now, are they born out of a Western tradition principally? I think the answer is probably yes, in a variety of ways. But I think that there's been an extraordinary dialogue that has been ongoing as to what are human rights, is something a human rights, that is driven by people from all over the world and communities from all over the world. So I do think that one can point to examples, at least as originally conceived, of what human rights are, and say these are Western constructs. But I also think that they were adopted, and these conventions, the vast majority of countries, are parties to almost all of these conventions, whether ICCPR, or, the country that's least adopted of these conventions because of our system and how we ratify treaties is the United States. We have not ratified CEDAW, which protects women's rights, and it sounds kind of nutty, because the basic principles in there we implement in our society, or try to, and we should implement in our society. And it's just been a failing that we can't get the requisite amount of senatorial support to ratify it. So I answered the question by saying, if it's not universal, then then we don't believe in the system itself. So it has to be universal for it to be meaningful.
Okay. So for this conversation, you've laid out 3 complementary approaches to advancing human rights. And the first of that being the multilateral human rights system, the second being bilateral engagement, and the third being domestic litigation. So let's go ahead and start with the first of those. You served under President Obama as the United States permanent representative to the UN Human Rights Council. Many years ago, I had the chance to attend a few Human Rights Council sessions and actually lobby at one of them on behalf of a humanitarian NGO. And so I had the sense that there were some very important people in this room who were listening to the things that members of the world community had to say. There was some deep discussions about really important issues, some really great reports put out by different special rapporteurs about very specific human rights issues around the world. But at the end of the day, has the Human Rights Council been effective at advancing human rights? And if not, are there ways that it could be more effective? And what has the role of the US been with the Human Rights Council, and how engaged should the US be?
Sure. All great questions. So on the effectiveness, I think it absolutely has been effective. Can it be more effective? It absolutely can be more effective. And I think that there's some specific ways to do that. When I say it's been effective, what I mean is, what is the objective? So the objective in my mind is to improve human rights over time, the observance of human rights by states around the world. And there are some innovative things that happen in the Human Rights Council that make it far better than its predecessor, the Commission on Human Rights. One of those is the Universal Periodic Review, and it's the unsexiest of things, right? Because every country around the world gets reviewed by every other country, and a lot of the recommendations are like, you should ensure that your criminal defendants have lawyers. Well, if a country then accepts that and implements that, that is a dramatic improvement of human rights in their country. But it's not sexy. It's never going to hit any newspapers, right? So when we think of human rights, I think, like anything, we naturally focus on the big issues, the big questions, like what's happening in Syria and how do we stop human rights violations there. But I think that the better approach is just to figure out what are the arrows in your quiver and which ones can you use most effectively. And certainly if you look at the record of the UPR as to recommendations made, it's on the 3rd cycle now, or it might be just started the 4th cycle. It's about every 3 years because it takes to get through all the countries. And what happens is every other country makes recommendations. Some of them are silly, right? I mean, Iran or North Korea, will tell the UK about, some of its human rights, and it's just, so. But you have to kind of separate those out, the silly part out, with those that are real. And if you look at the ones that are real, and you take the recommendations made, the recommendations agreed to be implemented, and then those actually implemented, the record is pretty extraordinary of how much has improved through the Universal Periodic Review. The other thing about it is, oftentimes with country-specific resolutions, because there's 2 types of resolutions at the council. There's what's called country-specific resolutions, and then there's resolutions that are thematic in nature. So during my tenure, one of our principal objectives was to get a independent expert appointed on what's in UN speak is called sexual orientation and gender identity, and sort of violence and discrimination against those sexual orientation and gender identity, basically LGBTI rights. And we were able to do that. And so what that expert does is it goes out and it does evaluations, it does reports. And oftentimes we in the United States, if we're criticizing a UN report, it doesn't hit our politics that much. But if you go to a lot of countries around the world, a report with the imprimatur of the UN criticizing that country has real political impact, and countries want to avoid it. So, if you take the country-specific reports, there is no doubt in my mind that some of them have had incredible effect. You take, for example, the Commission of Inquiry in Burundi. So 2015, Nkurunziza decided he was after all going to run for a third term, even though the prior Arusha court said he couldn't run for a third term. His puppet Supreme Court said, that's fine, he can do it. And, there were protests, there were a mass response by the state, killing people. And there's no doubt in my mind that between the attention that it got at the Security Council and the attention it got at the Human Rights Council with an emergency session, that changed the dynamics on the ground. It changed how the actors were acting on the ground. And I don't think that would have happened otherwise. I think another, and the other thing I'd say is we can't look at the HRC in isolation. I mean, we always looked at it as one tool, and we have the bilateral relationship. We have our allies putting pressure where necessary and appropriate. There's sanctions. And then you have these processes at the UN. So I believe that it can work effectively. I think that there are a number of legitimate criticisms of the HRC. And I think addressing those would make it have greater legitimacy and force. One is, I think that there are a number of members of the HRC that are just bad actors. And I just think that hurts the credibility of the institution. I mean, and I want to separate out the difference between bad actors without political will and then those with political will, because I think those are two very different situations. And for bad actors, or not bad actors, but human rights violating states, oftentimes they don't have necessarily the institutional capacity or the wherewithal. And the response should be to aid them in achieving those objectives. And I think we should invest a lot more in that. Really, for the naming and shaming, as it's called, really has to go to those states that don't have political will. And so those states should not serve on the council. The difficulty, it's hard to figure out a way to exclude them. So because they're elected in the General Assembly, and it's ultimately a political decision.
Right. Well, as you mentioned, the HRC doesn't operate in a vacuum. So let's go to one of the other important councils of the United Nations, the Security Council. So in 2005, the UN General Assembly adopted unanimously the concept of responsibility to protect, or R2P, which requires states to protect their populations from genocide, ethnic cleansing, and war crimes in general. But most importantly, puts in place this concept that if a state fails to do so, other states have a responsibility to step in and ensure that the state does so. And oftentimes, this is, or actually under R2P, this is the writ of the Security Council to decide when the world community should step into the affairs of a sovereign state in order to protect its population from genocide, war crimes, or ethnic cleansing. Has the UN Security Council done enough to uphold R2P? And when should it be authorizing military force to uphold human rights? How is it supposed to make that decision?
Well, your second part of your question is probably the most vexing issue in international affairs. I mean, because what you're trying to decide is on the front end, right, of a crisis, of a human rights crisis. Should you use military force, which itself can create ills? So how do you decide that? I mean, countries struggle with that, alliances struggle with that, and multilateral institutions struggle with that. So what I would say is, like, conceptually, I like R2P. I think it's right. I mean, that countries should have positive obligations to ensure that these extraordinarily bad, we're not talking about ordinary human rights violations. We're talking about gross and systematic. We're talking about war crime. We're talking about, genocide. Should countries have a responsibility? I think the question answers itself. Of course they should. I think the second part, the use of force part, is so tricky. And I think, given the dynamics of the Security Council presently, they certainly haven't used it enough. I mean, there's so many examples, but what happens is that countries are within the geopolitical orbit of one of the P5. And if they are, then they're going to frustrate the ability to use force. And that's what's happened in a number of situations. but yeah, I mean, you look around the world and Yemen, you look at Syria. So that the other, so conceptually, I get it. The other piece of it is where it has been exercised in Libya. It's certainly not clear that the military intervention was helpful in that situation. I think you can make an argument both sides that it would have been worse without it, because they were just about getting prepared to bomb in civilian centers. But I think you can make a strong argument, or a decent argument at least, that it is at least neutral or potentially worse. So it's one of those, it's one of the issues, one of the things in international affairs, I think, that it's all in the implementation, and the implementation is so challenging because we simply are unable to predict whether the outcome is going to be better or worse. And there's so many examples of that, right? I mean, everybody today, everybody would say to you, we should have intervened in Rwanda. I don't think anybody says we shouldn't have intervened in Rwanda with military force. And we could have been done with a relatively small footprint in light of Rwanda's military. I think that, certainly American decision makers would largely say Kosovo was correct. Libya, much tougher, right? Syria would have been much tougher call. And it's not at all clear what would have happened given the multiplicity of players in Syria, and what happens if it leads to sort of a greater footprint for ISIS. So I'd say that again, it's a good attempt to conceptualize. We have to now get to a place where we're trying to identify factors that will enable us to better predict when that military intervention is going to be successful. And I just don't think we've had that conversation effectively yet.
It's interesting you mentioned Libya. I was actually in Misrata in 2011 running a trauma field hospital during the NATO no-fly zone intervention there. And it's interesting to me because while I was there, I didn't meet a single person who wasn't thrilled about ousting Muammar Gaddafi, and a single person who wasn't supportive of the UN Security Council's decision to intervene militarily in that conflict. But then now, kind of talking to colleagues there years later, they're not so sure anymore. And so when the individuals in a country who are actually affected by the conflict can't decide whether outside military intervention was a good thing or a bad thing, it makes it really hard for the world community to decide.
Yeah, I mean, what is the lesson? You're exactly right. So what is the lesson learned of Libya, right? I don't know. It's not clear. So again, this is the most challenging issue, and has been the most challenging issue for a long time.
Right. So let's move on to one other aspect of the international multilateral human rights system, and that's the International Criminal Court, as well as other tribunals that had been set up beforehand in Rwanda and former Yugoslavia. How effective is the ICC and these past tribunals at holding accountable the perpetrators of human rights abuses? And should the US be ratifying the Rome Statute and joining the ICC?
My view is that yes, the US should join the ICC, because we have to lead by example, and we give others excuses, and accountability ultimately is essential for an effective human rights system. And what we have seen is that if you hold some people accountable for post-conflict, that has a real effect on how decision makers think about future conflicts. And so I think we should have an ICC. I think that the US should join it. I think we should empower it. The worry of US decision makers is that a US military personnel with our large military footprint around the world does something, and then they get prosecuted by the ICC. But of course, the ICC has built-in mechanisms to address that. And one of the mechanisms is to say, if you have a domestic system that's working, so are we really that concerned that somebody's going to look at our system and say it just does not work whatsoever? So I'm skeptical of that point of view. I think it's had a mixed record. I think that the ICC unfortunately got involved in a lot of African conflicts and African prosecutions and heads of states and things of that nature. And I think that, and I understand why, but I think that was detrimental to its legitimacy. And certainly it hurt. The case was easier to make that this was really about the global North prosecuting the global South. And I think if you have an institution that is tagged with that, it's just very challenging for it to be effective. But it has prosecuted a number of individuals, and former Yugoslavia tribunal was effective. Cambodian tribunals were effective. So I think these can be effective. And I think the good news is those involved in the institution are learning from their mistakes. And so I would say that if the US did participate, I think we would be able to shape it in a way that would make it even more effective.
Okay. So let's talk a little bit next about bilateral engagement, the second of your complementary approaches. So sanctions have, on the one hand, been promoted as a way to punish countries committing human rights abuses without the need for military force. And on the other hand, they've been criticized for having a disproportionately negative impact on the most vulnerable in society, such as by limiting imports of food and medicine, et cetera, into those countries, depressing the overall economy and increasing poverty. Are sanctions effective at curbing human rights abuses? And how can they be crafted specifically to lessen the impact on civilians while still holding accountable human rights abusers?
Yeah, this is an excellent question. And I think that in the first instance, I do think that they can be effective. They're not assured to be effective, but they can be. I don't think there's any doubt, for example, that the reason why Myanmar decided to have elections in 2010, and Aung San Suu Kyi was elected. I don't think there's any doubt that sanctions had a big impact on it. I mean, they cited sanctions as the big impact. So I think there's no doubt that they can be effective. I think we're getting smarter about sanctions. I think one way we're getting smarter is to take it from nations to individuals. Because if you're an individual and you cannot use the US banking system, or then you pretty much can't bank, because no other banks want to do business with you because they want to use the US banking system. So it really is painful. And so, in fact, in the Human Rights Council, there's a resolution called Universal Coercive Measures. And universal coercive measures are about countries like the United States sanctioning both countries and individuals. So I'm a firm believer that if you are a human rights violator, it should be a tool to be considered for those individuals to curb their problematic behavior. And that's the kind of idea of the Magnitsky Act and the Khashoggi list, for example, things of that nature. So I support that concept. I share the skepticism about national sanctions, and I think if they're done, they have to be very carefully done, because the potential vagaries are substantial. Not only the humanitarian vagaries, like you mentioned, with food and supplies and all kinds of things, but then there's a number of occasions where it has set the precondition for corruption, like the food for oil program, oil for food program. So I think you have to be very careful. It should be in very limited circumstances. The place where where individual sanctions are more challenging are places like DPRK, because North Koreans, they don't use the U.S. banking system. They don't travel to anywhere that they need to use it. So if you do individual sanctions there, they're just not going to be effective. How do you coerce a country like that to have the political will to make the changes necessary?
Yeah. So finally, let's move on to the third of your complementary approaches, which is what many might consider a novel idea, or some may not have even heard of, is the concept of using domestic law to advance human rights, especially here in the United States. So much of your career has been focused on using the law to advance the rights of Indigenous people here in the United States. Can you talk about some of the most important cases that you've brought? And more generally, has the law been an effective tool, in your opinion, to advance the rights of Indigenous people in the US?
Yeah, so I do think it has been and can be an effective tool. I don't think it can resolve all problems. You know, you take, for example, the case I litigated, which is the Cobell case that settled. It was about the mismanagement of, because Indians own land in the United States if they're trust lands. They're considered held in trust by the United States. So the United States acts as a trustee of the lands, but also the money. So if you say have an oil and gas lease, you don't get paid directly from the oil company. It goes through the system of the Department of Interior, and that's how the individual Indian gets paid. Well, that thing has been a mess for generations. And so we brought a suit and sought an accounting, and anyway, that's the one that settled for the 3.4 billion. But I would say that the actual losses suffered over the 100 years of this trust were far, far greater than the 3.4 billion. It's a measure of justice. And so one of the things that courts don't do very well is they don't deal with historical wrongs very well. So, you know, we're having this ongoing conversation in the United States about reparations, for example. That can't be dealt with through a court system. It's not the correct institution to deal with that. It has to be a political, I think, reality. And same for some historical things vis-a-vis Indian country. But yeah, I think on a whole panoply of issues, litigation can be a very effective tool and has proven so. Some things that some examples that come to mind, hunting and fishing rights. So a lot of Indian treaties were negotiated, and they said, okay, we're going to cede all this land, but we still get to hunt and fish in these lands. And there's been a lot of litigation about what does that mean. In the Pacific Northwest, the treaties say usual and accustomed places where they can fish. Well, that has meant that 50% of the annual take of harvesting of fish and shellfish in the Pacific Northwest goes to tribes and is co-regulated by the state of Washington and the state of Oregon. So that's a substantial right. It has economic benefit. And it's something that enforces a treaty that's 150 years old. So I do think that there's a full panoply of rights that can be enforced through the courts. The other thing I'd say is tribes have become increasingly effective in working with Congress to pass laws that also protect rights, like the Indian Child Welfare Act. We also have in the United States, not unlike a lot of countries, really this extraordinary violence against Indigenous women. In the United States, the racial gender category that has more violence than any other is Native American women. And unlike all other categories where the principal perpetrator is of the same race, for tribes, more than 50% of perpetrators are non-Indian. And so making this case to Congress in, I think, 2013, 2012, Congress passed the reauthorization of the Violence Against Women Act. And for the first time, it granted jurisdiction to tribes to prosecute non-Indians as well as Indians on the reservation. Tribes could already prosecute Indians, but not non-Indians. And so this changes that. So I think both through policy changes and increasingly because some of the courts have been hostile in recent years. So through policy changes, but also through litigation, you can certainly enforce rights.
Okay. So I want to move on to your current work and the landmark case that you just filed, I think it was last month in the US District Court against Mohammed bin Salman for the 2018 murder of journalist and activist Jamal Khashoggi in the Saudi consulate in Istanbul, Turkey, which is an incredible landmark case. And I was wondering if you could just start by saying how it's even possible to file a lawsuit against the Saudi Crown Prince here in the United States for a murder of an individual in a third country.
Yeah. So what we filed recently is our answer to their motion to dismiss. Filed that about a month and a half ago. The case was filed in October of last year. It took us a while or December of last year, late last year. It took us a long time, as you might imagine, to do what we call service of process. Service of process is where you actually take the legal documents and you hand them over. So we used a variety of methodologies. Some I can't talk about because it's under seal, and we still haven't served some people. But we were able to serve Mohammed bin Salman and a few others, and so the case is off to the races. He was the most important one to serve, obviously. And you asked a really good question. I mean, it is challenging to sue in the United States, but there's a law called the Torture Victims Protection Act. And this law actually allows you to sue for torture and for extrajudicial killing. And it's been interpreted broadly. In order to get jurisdiction, there does have to be some kind of US link. And here, we've argued that there are two links. There's settled case law, the Supreme Court case law that says that if you intended to have US impact by your overseas action, then that is sufficient for personal jurisdiction and sufficient under the Torture Victim Protection Act. And so there's a case in the DC Circuit that had to do with the bombings in Nairobi, and it was about whether there's jurisdiction over Al Qaeda. And the DC Circuit said yes, because it's clear that that bombing intended to have US impact. And so there's a series of decisions that have gone on both ways on that. But we think we have a very strong case because there's no doubt that MBS and his cronies were seeking to stop Khashoggi's activities in the United States. That's clear. And that's precisely what the intelligence community concluded as well. And then the second piece we have is that there were conversations between Jamal and Saudi officials in the United States that basically lured him to Istanbul. And those took place in the United States. So that's another individual, if part of your actions to commit a violation of the Torture Victim Protection Act happened in the United States, then of course the court can have jurisdiction. So we think we have two independent grounds for jurisdiction. And then there's the question of, does he have immunity from suit? And I think that the weight of the case law says that a crown prince is not the king, and therefore he's not head of state and he's not head of government. There's an immunity that is accepted in U.S. courts, and it's called head of state immunity. But you have to be either head of state or head of government. And in the Saudi system, the king serves both as the king and the prime minister, so both head of state and head of government. So we don't think Mohammed bin Salman enjoys that immunity. He could seek what's called a suggestion of immunity from the State Department. And that is typically considered dispositive. If the State Department says this person is immune from suit, then courts generally just go along with that. But he did not seek that in a different case called they did seek it in Al Jabri, a different case against MBS. And in that case, they did not get one way or the other. The State Department refused to answer the question. So that's essentially a denial. So we think what happened is that knowing that, they just didn't ask for it in our case. So basically we argue there is personal jurisdiction. There is a cause of action under the Torture Victim Protection Act and other statutes. And there is no immunity.
Okay. So before we open it up to questions from the audience, I wanted to conclude a little bit on a more personal note. We have a lot of students in the room, and I was wondering if you can tell us a little bit about your own pathway into the field of human rights. Is this something that you always thought that you would do, or something that you came to in a more circumspect way? And
both. So, I had two interests coming out of law school, and really well preceding law school. And, one was like Native American policy, law and policy, Native American rights. And the other was international affairs, national security, including human rights. And so, graduating from law school, there's not a lot of nexus between those two. So I kind of had to pick. And for all kinds of reasons, it was more natural to go on the indigenous rights route. And so litigated first with the Native American Rights Fund, and then, started a practice at a firm. but I always wanted to do something more on the regarding international relations. And so I say circumspect because, when Barack Obama won unexpectedly, I mean, everybody forgets that now, but at the time, it was unexpected that he was going to beat Hillary Clinton, at least talking to anybody in 2007. Of course, he won the election. I couldn't go in because I was still litigating the Cobell case. And so when he won re-election, though, they asked me what I wanted to do. And I was like, well, this is the perfect opportunity for me to finally get to do more of this. And like my wife calls me a foreign policy nerd. Like I read every foreign policy journal because I'm a foreign policy nerd. And so this gave me an opportunity to sort of exercise that. And so, my lesson is just, kind of be open to the opportunities and the possibilities. And if you are, you can do that which you're interested in.
Okay. All right. Well, let's go ahead then and open it up to questions from the audience. And we have two mics that our fantastic program manager for the Center for Human Rights and Humanitarian Studies, Seth Sulin, is holding. And so feel free to raise your hands and we'll bring over a mic. Got a couple questions.
I'm gonna kind of pass these down the line and ask that after you're done your question, you can hold the mic and wait till someone else has a question, then pass it on, just so I'm not doing laps around the room today.
And then here too.
Hi. Can you expand on your idea that the Human Rights Council should focus more on states with the political will to solve their human rights issues as opposed to something else? I didn't really get that idea.
Okay. No, it's so let me talk about it by way of a specific example. Central African Republic had these really bad situation, a lot of violence. And, we met with their political leadership and we were all convinced, it was the French, the UK, the United States, we were all convinced that they really did want to do the right thing. So they had the political will to do the right thing, right? Which was to have reforms on the ground, build a criminal justice system, not let people get away with killing people with impunity, secure rights for various communities, make sure that these leaders that were of gangs essentially were being brought to justice. But they simply didn't have the institutions to do so. They didn't have the court system. They didn't have control of the country. It was essentially a failed state. So in that kind of situation, to me, it always seemed kind of useless to just kind of attack them and say you're violating human rights, because you're not accomplishing anything. The problem is not the political will. The problem is not having the institutional capacity. The problem is not having the resources to do the right. And I think I always try to separate in my mind that kind of situation from, say, Eritrea, where you have a leader and a government that just grossly and systematically violates human rights across the board. You speak out against him, you're probably going to get kidnapped and killed. That's a situation where we can't just help them build institutions, because they're not going to. They don't have the political will in order to actually implement those things. And so that's where we need a different kind of approach. And the approach that the Human Rights Council has at its disposal is basically what is often referred to as naming and shaming, which is like, we're gonna do reports on you, we're gonna document your human rights violations, and we're gonna tell the world with the imprimatur of the United Nations just how bad of an actor you are. And so some people say, well, does that work? And the fact of the matter is, if it didn't work, these countries wouldn't spend the kind of resources that they do to avoid that kind of a report, because they do work, and because they ostracize, they distinguish them as rights abusers from the rest of the international community. And countries don't want to have that reputation. Does that answer your question? Yeah.
Reminds me, it seems like so often with so many things, including the Human Rights Council, we see the glaring failures, but not the quiet successes.
Yes, that's right. That's right. It's hard to, and the most challenging is where, you don't know what would have happened but for. right? Like, that's it's counterfactual. And it's just, it's hard to take credit for something that didn't happen. So,
I think we had a question over here next.
Hello. So we talk about the UN Charter stating states would have a moral obligation to intervene to restore peace and freedom within that state. What each country defines as peace and freedom varies, and there's cases where intervention even worsens the structure of the state because of this varying definition. We can see this in the case of American intervention in Guatemala, where the idea of violence and the goal of peace defined as Western democracy, worsened the situation. For example, the CIA orchestrated coup d'etat to implement their own head of state, led to a civil war in Guatemala, stifling its economic growth, putting an end to its political independence, and even leading to a genocide of Guatemala's indigenous people. What existing structures limit American intervention? And would you say limits are not applied to it in the same way it is to other countries because of the fact it is a partial hegemon?
a very good question. I think in my own personal view is that during the Cold War, the United States made a lot of bad choices, whether in Chile or Guatemala. There's just a number of places around the world. I think that there was this view that the Soviet Union was an existential threat, and their philosophy was an existential threat, and whatever we needed to do to stop that existential threat was okay. And I just think that that was a problematic view. Too many, I think, foreign policy decision makers had held that view. So I don't defend those kinds of interventions, especially when the purpose is to undermine a democratically elected. There's no doubt that Allende, for example, was democratically elected, right? He just didn't have the policies that were consistent with the policies that we thought were important at the time. When I say we, I mean the United States. So, I think that I would counsel not to utilize the examples within, or to think that the examples that emerged during the Cold War to counsel our current evaluation of the issue. Because I just think that whether you agree or disagree with the idea that the Soviet Union was this existential threat and their system was an existential threat, and they were trying to export communism around the world, and we had to stand in the way of that, and whatever we needed to do that was okay, or what we needed to do. Whatever you think of that debate, that is a different construct than what we have today. And so I think we do need to evaluate these questions of intervention. In my mind, there's some easy calls. I think that the intervention in Iraq was a bad call. I think that there's no real way to say that it was a good call. I think the evidence is pretty stark on that. I think Afghanistan is a little tougher because the United States was attacked, and under the UN Charter has a right to defend itself. And the government of Afghanistan at the time, the Taliban, was protecting. But now, 20 years later, as we pull out, is the situation better on the ground? And I think there's a strong argument that it's going to go back at least to some significant degree to pre-war. So I question it in that situation. Is there any? Your question asks, is there any limitation? And there is limitations in the UN Charter on the use of force. You can only use force if you are an ally are attacked, or alternatively, if there's a Chapter 7 resolution, and that has to be a breach or a significant threat to international peace and security. So I think that there's not necessarily an ability to limit the United States if it decides it's going to go into an intervention, even if it doesn't satisfy either of those prerequisites. Because at that point, it's just a situation of how do you stop it? So, I think that's a sort of realpolitik answer to the question. I do think that this entire area of intervention is one in which we need to have better rules. The US has to have better rules as to when we do this. When we make these as political calls based on shifting politics, then we run into a situation as we did post 9/11, where the politics were such that going into Iraq was supported by vast numbers of members of Congress from both parties. Because we don't have any sense of the rules that aid us in determining those decisions.
We have one question over here. Yeah.
Hello. Oops. First, I'd love to say thank you so much for your time and being here. This has been incredibly enlightening. My question for you, I'd love your personal opinion on why the UN has no power over US politics, while it does have power over some other large high-income countries. And should we change that? And if so, how?
Wow. I think part of it is that part of it stems from a good thing, which is that US policy is heavily criticized internally. And one thing is striking about the United States in a very positive way, in my opinion, if you look at our history, is our ability to self-correct. Just think about things that have emerged over time. Now, like Martin Luther King, the arc of the moral universe is long, but it bends towards justice, right? That it always takes much, much longer than it should have. But because of that capability, I think that things like UN institutions adding its voice of criticism just don't have the same political impact, because we're already having a robust debate here in the country. Look at what has happened with the debate on the use of violence by police against certain groups, particularly Black people. And that just the same kind of energy, political energy, is less likely, and in the countries where the UN has the biggest impact tend to be countries that are autocratic, so they don't ever hear criticisms. So if you do hear criticism by the UN, then that's a significant change in the political dialogue, because they're otherwise not criticized at all. And they tend to be thin-skinned because they're not used to being criticized, where, as you know, think about how we criticize our politicians here. I don't know if that's a complete answer to that. It's just a dynamic that I saw, and that if a UN report were to criticize the US for one thing or the other, it just didn't have that much weight in our internal dialogue. Should it? I wish it would. I think that, but I think it's something so deeply cultural here that I just don't think it ever will. And I think the other thing I'd say is there's a deep skepticism of the UN in the United States that is not shared by the rest of the world. So that's another driver for why we have that reality.
It's ironic, from the country that invented the UN.
Right, exactly.
Over here and then over here next.
Hi there. Thank you so much for sharing your fascinating perspective. My question is, of ongoing global human rights abuses, what is one instance that you believe to be critically overlooked, and what policy recommendation might you have? And also, second, do you believe that the US could ever ratify CEDAW? Thank you.
I think there can be a political reality where we ratify CEDAW. I'm, with reservations and that kind of thing that we normally do anyway. I can't predict when that will happen, but the other thing is we're not very good at predicting. I remember we were invited by so there's this tradition of the council that the president of the Human Rights Council would invite people to their home country to have a 2-day, 3-day meeting. And so the German ambassador invited us to Berlin, which by the way is an awesome city. So one of our favorites. So we were in Berlin, and part of it is they were doing a tour of Berlin, and we went past the wall, and his name is Joachim Rucker. I said, Joachim, you were here because he was in Berlin a couple, 3 or 4 years prior to the fall of the Berlin Wall, and I said, when you were there in that time period in the mid to the late 80s, when did you think this wall would fall? And he said, not in my lifetime. And I think that just tells us that we don't know until things happen, and things happen even when we don't have eyes on them. So we're not very good. We're not very good at predicting. And so I'm gonna, hope springs eternal that the Senate will finally get its act together and ratify CEDAW. What was your first question again? Just quick, 2 seconds.
An ongoing and overlooked human rights abuse.
Wow. I think DRC is one that is really not is overlooked more than it should be. I mean, it's pretty bad, and it's both human rights and humanitarian, and it's been bad for a long time. It's just really bad. I mean, it's at the state of not good, and then it has these periods where it's like in a state of utter crisis, and I think it's at a state of utter crisis right now. The other one I would say is, I think that the international community's failure to effectively call out China on Uyghurs is just unconscionable. And we are going to look back at this period. We're going to look back at this period, and we're going to say, this is another time when the international community utterly failed with gross and systematic human rights abuses were happening right in front of us.
Thank you.
You had a question here?
Thanks for coming to talk today. You discussed the right to protect, and specifically how countries have an obligation to basically respond with possibly military force if the country itself does not honor the right to protect. And you also discussed specifically how it's considered by many that China is either committing a genocide or taking steps towards committing a genocide against their Uyghur population. In the event that a Security Council country is committing egregious human rights abuses that violates the right to protect or violates any other treaty or declaration, what steps or tools can the UN take to prevent this?
The toolkit is limited, other than political criticism. There's not much. And part of it is just a geopolitical reality. I mean, because what's the alternative? The alternative is the United States goes to war with China over Uyghurs, or us and our allies. And I just can't see us doing that. That would just be too big of a thing. So I think what's happening is that the US appropriately criticizes China. I think I'm happy to see that there has been discussions within the UN system on Uyghurs. I hope with the United States rejoining the Human Rights Council that we will make more of an issue of it. They were heavily criticized by a number of countries for Uyghurs during their universal periodic review. And it had some effect, I think, but not nearly enough. So the short answer is, I mean, we're not going to go to have a hot war with China or Russia based on a domestic situation. It's just, because of the consequences are just too significant otherwise. So that's the unfortunate reality, is that you try to use these, not particularly effective tools, because even things like sanctions are difficult in those circumstances, because some of the decision makers, they're susceptible to sanctions. And certainly we've used sanctions with the Russian Federation, and they're a P5 member. and that had to do on a number of levels, but it included their actions in Ukraine. So that's a situation where you had a state that was really committing violation of international law that had real human rights impact in another country, and we took steps through sanctions. So sometimes there are things that you can do like that nature.
Question in the back.
That one over to you. I'll let you take this one coming on. And then we have another.
Thank you for sharing your time with us. I wanted to ask, specifically referring to your expertise in indigenous rights, what your thoughts are on the Palestinian situation and what you think, what role the US could play or should it not intervene at all regarding this matter? Thank you.
So, I mean, obviously, it is an incredibly challenging situation. Let me explain first that within the UN setting, one of our roles is for the United States is to try to rebalance the council, because Israel is sort of on the agenda more than anybody else. And so, you know, my personal position is that no country should be free from criticism. And certainly there are things to criticize Israel for, but also no country should have a different measuring stick than any other country. And that's the unfortunate challenge at the UN, is that you have this hyper focus on Israel. Now, with respect to the situation on the ground, I would say a couple things. One, we do have to take the idea of Israel's security seriously. On the other hand, there are a number of things in which we should be more influential in their domestic policy decision-making. I mean, the expansion of settlements that make it extraordinarily difficult, if not near impossible, to have a two-state solution. The United States ought to be leading in pushing on that issue. We have a lot of leverage. And the treatments of Palestinians, while again, I fully support the notion of Israel's right to protect itself. I mean, every country should has that right to protect itself and its people. And part of the challenge is that people tend to take one side or the other without seeing it in a balanced way, that both the Palestinians and Israel have equities that we ought to honor. And I do think the US can play a much, much more significant role in trying to get a resolution. I mean, we've tried to get a resolution. There's no doubt in my mind that there have been repeated efforts. But I think this is one in which we have to double down on those efforts. And that's good. And at the end of the day, that's the only thing that's going to secure Palestinian rights and Israeli security.
Hi, is this on?
Yes.
Okay. Ray Gould, welcome to campus. I have been meaning to say hi. Thank you so much for being here this year. I think about UNDRIP all the time in my world of Native studies, and I'm wondering if or I'd love to hear any ideas or thoughts that you have on how to potentially, in some way, maybe give that more backbone, if there's any possible way to do that.
Well, one of the things we tried to do through the World Conference on Indigenous Peoples in 2014 and the development of the outcome documents is to strengthen UN institutions, or to call for the strengthening of UN institutions regarding UNDRIP. Oh, sorry. Yeah, the UN, the Declaration on the Rights of Indigenous People, the UN Declaration on the Rights of Indigenous Peoples. It was negotiated for 30 years, and 15 of those years were arguing about whether there should be an S on people. And finally, there was an S on people, so that was resolved. And then it was generally adopted. I want to say 2007, but I could have that wrong. The United States did not vote for it. President Obama then did support it, and therefore it's kind of universally adopted at this point. So one of the things that we did in Geneva is that there is a mechanism called the, or basically a mandate holder called the Expert Mechanism on the Rights of Indigenous Peoples. And we in 2016 strengthened that mechanism considerably, giving them independent evaluation authority, and mandated that they look at article by article of the declaration and determine how states are doing, what are the best practices that are emerging in order to implement the principles set forth in the UNDRIP. I am not for a treaty. I don't believe that we should move in that direction. And the reason is simple, that, you know, we kind of think of, when we think of international law and policy, we sort of adopt rules of how we think about domestic law. And in domestic law, there's a real difference between hard law and soft law, right? Because hard law, you can go in a court, you can enforce it, you can get an order, you can go seize property, you can go, you know, in some cases get people prosecuted. That's hard law. There's coercive mechanisms for compliance. In the international community, the difference between hard law and soft law in the vast majority of circumstances is not that substantial. And I don't think we can get the principles and the articles as set forth in the declaration in a treaty. We'd spend 20 years negotiating it. It'd be watered down because now they're hard law. Yet I don't think it's going to advance the issues very much, because you still have the problem, just like with any convention. Yes, you get a review mechanism through, you know, the Convention Against Torture, you get the review by the Committee Against Torture, but it's still just persuasive. It's still just political in nature. So I don't see that as being particularly helpful. I do think that one thing that we were not able to achieve with the expert mechanism, and one thing it should do, or one additional reform, would be to make it like a review entity for a convention, so that you would be assessing every country with indigenous peoples as to how they're complying with the declaration.
If that were to happen, how do you think the US would rank up against other countries around the world, indigenous peoples?
In some ways, very, very good. And in other ways, very, very poor. You know, and I spent a career criticizing some US policies on Indian rights, but I don't think there was any country around the world that would pass a law that said indigenous courts can prosecute non-indigenous peoples. It just wouldn't happen. I mean, the Maoris don't even have courts. The Canadians don't have courts. Most indigenous communities don't even have courts. And then to take the steps of making that sovereignty so strong that they can actually prosecute those who are not just members of their community, that's pretty extraordinary. So in some ways, I think with a lot of advocacy from people that preceded me, we have achieved a lot. Indian Child Welfare Act, for example, which, you know, makes it very challenging to break up an Indian family and to adopt them out of the tribe, which is good, because prior to the Indian Child Welfare Act, 25 to 35% of Indian children were, depending on the reservation, were being adopted out. So, and if you look at, since in this what we call the era of self-determination, which started with Nixon in 1970, and you look at, you know, how things have developed since then, tribes and tribal communities are, you know, certainly existing challenges, but tribes are better off today, and their communities are better off today than they were 10 years ago. And 10 years ago, they were far better off than they were 10 years prior to that. And that goes all the way back for the last 50 years. So I think the trajectory is in the right place. I think there are certainly policies that, you know, deserve to be shifted. I think, you know, kind of, but I think that the ongoing conversation is a healthy one. And so by and large, I think we stack up fairly well. There are some countries like the Nordics and the Sami, for example, that they do better. But they do better in most human rights stuff than we do. So it's not particularly surprising. They have it built into, I think, their political systems in ways that we have, that we don't. Does that answer your question?
Just thinking earlier about the question about state intervention, and then also your earlier point about reparations. Do you think that the United States currently holds any financial or social responsibility to pay reparations to countries that may have suffered some sort of unrest after American intervention in those countries?
Wow, that's a good question. I haven't really thought about that question much. I certainly support domestic reparations. I think maybe it just depends on the circumstances. And then I wonder whether calling it reparations as opposed to enhanced aid of some sort is a better framework for domestic politics. So I think there's a couple questions embedded in your question, and that's why it's a challenging one. One question is whether we should do it. The second question is, if we do it, how do we do it, given domestic politics that have to be part of that conversation, right? We need to, if you're going to want to do it, you're advocating, you've got to convince people that it's the right thing to do. And that, if you call it reparations, and this is why the reparations from slavery has been such a fraught conversation, even though by any moral consideration, to me, it seems fairly obvious. But because you're making an admission of wrongdoing in a way that's hard for countries to make, and that's just a sort of political reality. I do think that it makes sense, and this question does come up. It more comes up in the context of former colonies and European powers in particular, and whether or not the extraction of wealth from these countries, that there should not be some reparations for that. But for countries that we've gone to war with, I think it would depend on the circumstances, and then we would have to think about the implementation.
Well, certainly we have spent trillions of dollars in some countries that we've gone to war with. The question also is not just whether you do it, but also how you spend that money.
Yeah, exactly. Well, and there's you're right. There's successes, right? The Marshall Plan was a success, and the country that got the advantage of the Marshall Plan was, among others, was Germany. So Western Germany was an issue.
Is this turn? Okay. Okay, sorry. So again, thank you so much for being here. So my question is, there's emerging terms of digital colonialism and also oppression. And so with emerging technological capabilities like surveillance, how can councils and states recognize human rights abuses that are perpetuated by technology? And what are your top concerns about this?
Yeah, right. So I'm a Luddite, so I don't like thinking about technology. I'm a technophobe, but I don't think there's any doubt that this is a huge question that we don't yet have answers for, and it's multifaceted because, as you raised, there's a surveillance issue. There's the issue of what's online, what should be online, what shouldn't be online. There's the issue of algorithms and how does that play with our notions of freedom of expression? Because the U.S. conception of freedom of expression is distinct. No other country shares our broad view of free speech. I mean, we have case law in this country that said Nazis marching down the street, 20 years after World War II and the Holocaust, in a Jewish neighborhood, could march down that street because it was freedom of expression. I mean, that none of our closest allies don't have that kind of broad view of freedom of speech. So, but critical to that view of freedom of speech has been the idea that you don't ban speech, but you beat bad speech with more speech. That's been the conceptual framework that we've thought about that construct and supported that construct of a broad view of freedom of expression. But now when we have these algorithms and, you know, you look at something and so the algorithm says you should look at something similar because that's what's going to keep you interested. And then another thing that's similar and another thing that's similar, then you're not capable of beating bad speech with more speech because you're not seeing any more speech. And so I don't want to, you know, I'm close to a free speech absolutist, generally speaking, but I'm worried about that dynamic. And I wonder whether or not, instead of trying to do something on the free speech side, we ought not try to do something on the regulation of how these algorithms work. I'm not advocating that because I don't know enough about it, but people who are smarter than I am on this stuff need to kind of think about that. And then on the surveillance front, you're absolutely right. I mean, the ability to surveil, to have facial recognition and all of these does potentially invade our lives in ways that are substantial. And I do think we ought to be thinking about, you know, new rules of the game on what's acceptable. Now, the one challenge I have, or the one question I have, and I don't have an answer to this, is that better in a domestic conversation, or is that better in an international conversation? And maybe it's better in both. Maybe we should have it in both circumstances.
Probably time for 2 more questions. All right.
So I have, hi, thank you. I was wondering if you think that the UNHCR and the human rights community will be able to hold Sri Lanka accountable for the human rights violations during the civil war, and if so, what would sort of the pathway for that be? And is there a role for the diaspora in that process?
It's a great question. I spent a lot of time working on Sri Lanka. So by way of background, there was a group called the LTTE, often referred to as the Tamil Tigers, and there was a civil war for decades in Sri Lanka. And then there was the ending of it, I think 2009.
Yeah,
I'm getting wrong. And there were massive human rights violations as it ended. You know, rape of people, just indiscriminate killings. I mean, just incredible atrocities. And there was no serious domestic accountability. And so the United States and the UK led an effort at the Human Rights Council starting in 2013 to have resolutions passed. And it was really effective, actually. And one of the reasons why a gentleman by the name of Sirisena won his election in 2015, I guess,
yep,
was that he cited the ostracization by the head of state at the time was Mahinda Rajapaksa, and he basically blamed him for Sri Lanka's ostracization by the international community, and that was a huge political issue that allowed Sirisena ran on and won unexpectedly in January of 2015. So that's a really important demonstration of how a resolution of that sort can have a real political impact in a country. And then after that, you know, in 2015, we passed a resolution, and one of our resolutions was both supported by the Tamil diaspora community and Sri Lankan government. So we got all the parties together to agree to this resolution, in part because they had I forget his name, but a really forward-leaning foreign minister. And what that did is it called for a court system that had both domestic and international judges. And that was really important. The international judges are important, so it's not just a domestic matter, but the Sri Lankans really wanted Sri Lankan judges involved as well. So it called for this. And then I think that was 2016. And then, of course, we didn't really get to see it implemented because I left in January 2017. And I don't think the same energy was placed in it. So I tell that history because Sri Lanka could have been a shining example of how you actually build through the Human Rights Council an accountability process that actually worked. I think the US, because of domestic politics, lost energy to support that. And unfortunately, it didn't get, it didn't go through. How does it happen today? One of the challenges of today is one of the guys who is principally responsible, Rajapaksa's brother, for the atrocities is now head of state. So that's a challenge because anytime you get head of state, that makes it much more difficult, as we saw with some years ago in Kenya. So I don't exactly know. I think there may be another effort to revitalize that and actually build this court that can then try some people. And even if you can't get the head of state, at least you can prosecute some of the other key leaders. And I think the case we made to Sri Lanka ultimately was that you need to address this issue, that if given the dynamics between Tamils and Sinhalese and Muslims in the country, if you don't have some accountability, then you're just going to incentivize people taking drastic actions. And so we were always of the view that in order to get past this, if you look at a lot of conflicts around the world, internal conflicts, certainly South Sudan is a good example. A lot of it goes back to generational conflict, like communities that have been fighting each other for sometimes hundreds of years. And if you don't have accountability somehow for the most recent atrocities, then they'll just continue into the future. So we always thought that for Sri Lankans' own benefit, if they wanted ultimate stability going forward, they had to have this kind of process. And at least the Sirisena government agreed with us on that.
Thank you.
One more question. If there's no one, oh, we have John here. He started us out, and so we'll let him finish it off.
Thank you. And in my excitement to introduce Adam and Keith, I forgot to introduce myself. I'm John Hirsch. I'm a visiting scholar at the Center for Human Rights and Humanitarian Studies this year. So you mentioned, the U.S. perception of the Soviet Union as a existential threat. I thought maybe you could comment on a real existential threat, which is climate change, and what can be done in terms of the relation to human rights and any like any of the human rights litigation about this issue, particularly in Europe, where there's been a little more headway than here in the United States.
Yeah, I thought that the Dutch case was absolutely fascinating, and I'm glad that they were taking that approach. Look, I think that we ought to use all weapons. This is it is existential, and we need to use all arrows in the quiver. I'm not against the human rights approach to it. Obviously, it's going to have human impact, but I guess I would ask the question a little bit. The other question is that, and I don't have it settled in my mind, is that going to be the most effective approach? We oftentimes talk about goals paradigm versus rights paradigm, and goals paradigm, like the Sustainable Development Goals, can often have some benefits because they depoliticize an issue, and they just say everybody's going to work together to achieve this goal, which is whereas human rights is often an issue of criticism. You're undermining human rights, and so the question I would have is, are we advancing the conversation to a greater degree by having it as a human rights dialogue rather than the present one, which is, the Paris Accords is a goals dialogue. And I don't know the answer to that question, but that would be the question that we have to litigate, I think, in order to understand what, because I think there are and if we're going to do it the human rights, if we are going to go the human rights direction, we have to think about how are we articulating what the right is, and how are you violating? How are states violating those rights by not agreeing to certain goals, by not taking action on carbon emission? So those are the kind of questions I think that we would have to think through in order to have the conversation be a rights conversation.
Well, on behalf of our Center for Human Rights and Humanitarian Studies and the Watson Institute for International Public Affairs, I want to thank you for coming and joining us this evening.
Great
and
question.
I want to thank all of you who joined us here in person for this event and all of those watching online through our streaming site on YouTube. Thank you so much, and we look forward to seeing you at future events. Thank you.